letter.
Yes.
We received that letter dated February 23, 2012, requesting that Mr. Eric A. Borlongan, chauffeur, and Christopher Doliente, security guard of the Supreme Court, be excused from testifying pursuant to the subpoena ad testificandum issued by the impeachment court made upon request of the House panel of prosecutors, for the reason that they will be asked to testify on the cases of former President Gloria Macapagal Arroyo and Jose Miguel Arroyo, which are pending cases before the Supreme Court. So may I also include that in the motion, or another motion, to be taken up on Monday, Mr. President,
Yes,
during
in
the
the
caucus?
caucus, yeah.
Yes, as agreed upon in the
Any
caucus.
objection? Hearing none, the motion is approved.
Thank you, Mr. President. Mr. President, there are two more judges who would wish to ask questions
proceed.
to the witness.
So that we will not require the return of the distinguished
Yes, so that, yes,
Secretary of Justice. Let's proceed and finish.
Mr. President, yes. There is a fourth soldier in the hall. I forgot. The Lieutenant Colonel Loren Legarda, Mr. President, of the Reserve Officer Corps.
The distinguished senator who graduated from the National Defense College.
Yes, Mr. President. By the way,
With
Mr.
the
President,
rank of colonel.
rank of Colonel, Lieutenant Colonel. By the way, let me just make sure that it is understood. She's going to be the first Brigadier General. Senator Lacson was General Lacson. Lieutenant senior grade. Senator Trillanes was Lieutenant senior grade. Senator Honasan is DD. Dishonorably discharged.
The gentle lady from Antique, Malabon, Manila, and the Republic. Has the floor.
Mr. President, I'm certain that the majority leader can only say that of Senator Honasan because they are the best of friends. And he would be the only one to dare say that. Pag iba nagsabi daw susuntukin ni Greg. Hindi. I assure you, hindi nanununtok ng tao si Greg. Maaring ibang ginagawa niya pero hindi nanununtok. Simple lang po ang aking katanungan kay kagalang-galang na kongresistang Raul Daza. Hindi ko po tatanungin ang ating testigo. Just very simple. Article 7 charges that Chief Justice Corona it was partial in favor of former President Arroyo, which, as you say in your impeachment complaint, constitutes betrayal of public trust. Is that correct?
That's correct.
Yes. May this representation be enlightened as to the degree of partiality and or bias that will warrant such removal from public office of the Chief Justice. In short, I want to understand the threshold of bias and partiality that the Chief Justice exhibited that would warrant his conviction and convince this court that as far as Article 7 is concerned, he has to be convicted on this count.
Yes, is the question of the distinguished senator whether the conduct of the Chief Justice amounted to betrayal of trust? Is that the thrust of the question?
I will repeat my question, Mr. Prosecutor. What is the threshold of the degree of bias and or partiality exhibited by the sitting Chief Justice that would warrant him removal from office if and when he is convicted by the impeachment court?
Well, the partiality should be proved by the quantum of evidence that is somewhere between substantial evidence and proof beyond reasonable doubt. It's somewhere between that.
Substantial
yes,
evidence and proof beyond reasonable doubt.
somewhere
but that covers already the whole spectrum.
No, somewhere between that.
Clear and convincing evidence,
that,
perhaps?
The problem is that I've been researching, although not as thoroughly as the distinguished presiding officer. I have not found from my research, either from U.S. authorities or from authorities in the Philippines, which fixes that quantum of evidence necessary to convict in an impeachment trial. It's just that it's somewhere between
I will rephrase my
substantial
question.
evidence.
I understand your answer,
With the
however,
permission-
I completely want to understand.
With the permission
Yes,
of the
Mr.
lady
Presiding
senator.
Officer.
If you study Charles L. Black, Jr., written, who is from Yale, and Raoul Berger, who is from Harvard, you'll see there that it would seem that the requirement of the quantum of evidence required this overwhelming preponderance of evidence. Although there are indications that clear and convincing evidence is enough. So anyway, that will be a matter that will be
Yes,
discussed in due time.
to confess, in all candor, I'm unable and I'm not competent to answer that question with
certainty.
credibility. I wouldn't want to answer that in a manner that I
That
would
is
be
fine, Mr. Prosecutor. We
yeah.
appreciate your candor.
I think if I don't know whether I think the question, as I understood it, is asking for what is the degree of partiality that will equate into a betrayal of
Public trust.
public trust. Was it repeated partiality, one partiality, two partiality, three partiality? I think that's the...
The presiding officer is correct in trying to interpret the question which I posed before the prosecutor.
Well, if all the individual acts or actions of the Chief Justice in relation to the TRO that has been the subject of the testimony is proven by sufficient evidence, whatever is the quantum that may be decided by the court, it is our humble submission that that would constitute betrayal of public trust.
Anyway, when the defense turn to present their evidence will come, I assume that they will, a witness from their side will be presented to explain many of these things that are being discussed now. So we will see at that point which one is the more weighty story against the other. Okay?
Yes, let me ask the question insofar as this TRO is concerned with regards to Article 7. What did the Chief Justice manifest or do that he is being charged with betraying public trust through his biased action, opinions, decision, or his so-called partiality?
Yes. Well, as testified to by the witness and from my reading of the dissenting opinions, there were individual acts of the Chief Justice that together, when put together or pieced together, would show that partiality. Among others, one, the fact that because he had the power or authority to decide on the agenda of the court, the two consolidated petitions were agendaed, shall we say, with some speed. I wouldn't want to say indecent speed. Number two, being the Chief Justice, it was within his authority under the internal rules to order that the respondent, Secretary of Justice and the other officers, be first required to comment on the petitions, even if given due course, with the end of view of considering the TRO. Number three, the ponente to which the two petitions were assigned on the issue of TRO recommended a hearing And yet, that recommendation was not heeded. Well, of course, number 4, as testified here just this afternoon, on 2 at least occasions, his spokesperson, Mr. Marquez, misrepresented what really happened within the court, and yet his spokesperson, Mr. Marquez, was never corrected for the interest of the public on those erroneous announcements. And plus, another is the matter of the efficacy of the TRO was assigned to Justice Velasco as ponente. The understanding was that he was going to sit down with Justice Carpio on that clarificatory order. But the Chief Justice on his own broke that and then put on his own version of the clarification of the temporary restraining order and several other acts. Now, one act we submit is not sufficient to prove partiality. But when there are so many acts and all of them show a pattern that would show favoring the former First President, we humbly submit, Madam Senator, that the proof of partiality there is strong. And that if we submit, this impeachment court agrees with the version of the prosecution based on those facts, even only on this count, because there was betrayal of public trust, the Chief Justice should be removed.
Ang sinasabi ba ninyo, Mr. Prosecutor, na dahil sa kanyang pagmamabilis ng pagbigay ng TRO ay una, minadali, pangalawa ay minaniubra niya ang desisyon nito para paboran ang dating Pangulo.
Tama
So
po
in
yun.
sum, yung inyong 5 minutong paliwanag ay isa sa ilalim sa isang sila, minaniubra bilang Chief Justice ang desisyon? Ganun ba ho?
Ganun po.
Sa-
Ito po yung nangyari nang dahil siya sa ilalim ng tinatawag ng general rules of the court, may kapangyarihan. That
Maski
he
po
will
collegial
get-
body ang
he
Supreme
will
Court.
get authority and power as Chief Justice to influence the individual justice. And not only that, as I mentioned, gaya po na nasabi ko, talagang lantad, tahasan po, na talagang sa kanyang ganang sarili, pinakialaman pa niya ang gawain ng kapwa magistrado ng Korte Suprema.
Gusto ko pong maintindihan kung paano po niya inimpluwensya ang desisyon ng ibang mga kasamahan niya sa Korte Suprema para po bumoto sang-ayon ayon sa inyo, pananaw.
Hindi, kanya nga po ang ginang senador.
Did he bribe, coerce, harass any of the members of the court?
Hindi naman po kailangan takutin o haras ang kapwa magistrado. Alam po naman natin na sa takbo ng buhay, hindi lamang sa Korte Suprema, kundi sa anumang pangkatin sa ilalim ng ating pamahalaan. Pag ang isang namumuno, lalong-lalo na ang punong magistrado, gamitin ang kanyang kapangyarihan, ang kanyang influensya sa kapwa magistrado, hindi na po kailangan takutin. Bulungan lamang, kausapin lamang.
At yun
Pero
po ang
mahalaga
sinasabi
po,
niyang
Madam
ginawa niya.
Senadora, ang mahalaga po hindi po yung kose, kundi yung epekto po yung nandyan The reality of what happened, how it happened, is not really as important as what really happened.
Thank you, Mr. Prosecutor. Sa takdang panahon po ay pakikinggan ko naman ng depensa ayon sa sinasabi niyong pagmamaniubra ni Chief Justice Corona sa pagbibigay ng TRO in favor of former President Corona.
Maraming salamat po,
po.
Ginang Senadora.
Just the floor, leader.
Finally, Mr. President, the Minority Leader, Senator Alan Cayetano.
Senator Cayetano.
Magandang hapon po, Mr. Senate President, sa ating po mga colleagues. May mga tanong lang po ako to clarify sa ating pong witness sa ating Justice Secretary. Ma'am, good afternoon.
Good afternoon, Your Honor.
Ma'am, are you familiar
Mr.
with
President, Mr. President, may I just be, the senator will be asking questions to the witness. In the meantime, may I be just excused to go out for 1 long minute?
Let us, before the gentleman from Taguig will proceed with his
Yes.
questioning, suspend the session for 1 minute.
Thank you, Mr. President. I mean,
There's no TRO. You may, for your 1 minute.
Adjourn till Monday. One long
From Gabaldon. Dito ka ba din Gabaldon? Si Basic lang yung tawag din.
We'll wait for her. Nandiyan na. Si Raul. Si Raul Daza. Kasi, trial resume. Majority floor leader. The minority floor leader has the floor.
Thank you, Mr. President. Ma'am, may I know if you're familiar with the internal rules of the Supreme Court, particularly Section 2, which deals with confidentiality?
More or less, Your Honor, because I read that.
Para lang po maintindihan ng mga nakikinig at nanonood sa tanong ko po, with your permission, I'll read it na po. Section 2, confidentiality of court sessions. Court sessions are executive in character, with only the members of the court present. Court deliberations are confidential and shall not be disclosed to outside parties except as may be provided herein or as authorized by the court. Section 2 po yan, Rule 10, SC Internal Rules. Ma'am, sabi niyo po kanina nabasa niyo yung kay Justice Sereno and Justice Carpio na dissenting opinions.
Opo.
Di ba po, nag-discuss din si Justice Carpio na pati yung nangyari sa loob ng deliberation ay pwede nilang ilagay at hindi to violation ng confidentiality. Pwede nilang ilagay sa dissenting opinion.
Opo. Kay Justice Sereno rin po. In fact, he was saying na matagal na daw po yan na pwede ginagawa ng Supreme Court from 1950s up to she appointed to a particular duration where she knows that there are cases where it's being disclosed, the manner of voting, who voted this and who voted that, and the reasons for the voting. There are examples in the case law.
And you were pointing kanina na yung substance o yung ratio decidendi, halimbawa na po yung reason for the decision or yung rationale, hindi yun ang kine-question mo dun sa, you're questioning that sa court, but ang kine-question nyo dito, yung peculiar instances or acts that would lead to a belief of partiality na nakita nyo dito sa dissenting opinion.
Opo.
Okay. Except that, since kayo nag-testify, may discussion kanina tungkol sa hearsay, dahil hindi po isang justice na Supreme Court na nandun ang nagte-testify at hindi natin hawak ang records nila. So far, am I correct? No?
Opo.
Okay. Naalala niyo po nung private lawyer pa kayo or nung nasa Commission on Human Rights pa po kayo, malaking issue po yung kay Secretary Neri. Kasi sinabi daw na may 200 ka dyan, allegedly ni Chairman Abalos, at sinabi daw sa Pangulo, at tinatanong namin dito, anong sagot sa iyo ng Pangulo? And ang nangyari, they ran to the Supreme Court and claimed executive privilege.
Opo.
At inuphold to ng court at sinabi, ang deliberations from the President and high-ranking officials, meron yang executive privilege.
Yes.
Similar po yan sa privilege ng justices. Na pag sila nagdi-discuss, may privilege sila, judicial privilege or executive privilege, deliberative privilege, whatever you call it. May confidentiality po yan.
That seems to be the essence of that provision that you cited earlier, sir.
Kami po, pag nagko-caucus kami, ganun din, may confidentiality, no? May exceptions po ba itong confidentiality na to? O yung privilege na to?
You're referring to the
Any of them po, executive privilege or the judicial privilege. Kasi the point of this case is that may partiality dito na hindi punto yung hindi nyo gusto yung desisyon. Ang pinupunto nyo dito kasi, kung tama ang pagkaintindi ko, may maniubra dito. Kung hindi nyo lang gusto ang desisyon, wala tayong impeach o wala tayong pag-uusapan sa impeachment court because people lose cases every day and you win some, you lose some, you just have to argue your case. But kung ang tingin nyo na may illegal o immoral na ginawa, kaya mali yung desisyon, hindi dahil mali lang siya, kung hindi dahil may ginawa, na falls under the grounds for impeachment, and in this case, betrayal of public trust, yun po yung tinatanong ko kahapon kay Congressman Daza. So, ang problema ho, parang nababox in tayo because of this confidentiality. So I'd like to understand, before we go into caucus on Monday, your stand as the Secretary of Justice, no? Not only as Madam Leila or Attorney Leila de Lima, but as Secretary of Justice. Sa discussions po kasi halimbawa sa Nery case, malinaw na sinabi ng Supreme Court, kapag ka ginagamit yung executive privilege to discuss a crime or to hide a crime or to commit a crime, that's an exception, hindi po ba?
Opo.
In the case of the the deliberations ng judiciary, meron din pong bang exceptions?
Doon po mismo sa provision na sinike nyo, mukhang wala. Pero, na-discuss din po ito sa dissenting opinion ni Justice Sereno na pwede kapag ang issue ay tungkol na doon sa accuracy ng mga pinag-usapan o ng mga botohan, na may dispute doon sa kung ano talaga ang mga nangyari sa loob, lalo na doon sa botohan.
Okay.
So that's her duty to disclose that.
But does that exception apply only to her and justices or to any one of us? Pwede ba nilang ilantad or through the dissenting opinion lang po?
Anyone.
Okay. Let me follow up that question later on. No? Yung Nery case po kaya, would you think as the Secretary of Justice applicable then if a crime is being committed or being discussed, if in effect, halimbawa po, whether it's Congress or the President of Judiciary, may executive session, nag-uusap, pinag-uusapan bribery, o bibigyan tayo ng ganitong milyon, hati-hatiin natin. Yung isa ba sa kanila, pwedeng biglang pumunta sa inyo magsumbong dahil sabihin, hindi na to covered ng judicial or executive privilege or legislative privilege. Kasi pinag-uusapan na dito, krimen.
Opo, that's outside of the privilege.
And tinignan ko po kasi dun sa, si Justice Carpio may sinite din po siya, yung case po ni Williams versus Mercer. Ang sabi po dito, the privilege of judicial communications, however, is not absolute and must yield if significant interest outweighs a judge's interest in confidentiality. For example, the demonstrated need for evidence in a criminal prosecution or in an investigation of judicial misconduct warrants an intrusion into the confidential judicial communications. Ito po bang impeachment is a form of investigation into judicial misconduct kapag ka-justice na Supreme Court ang ating nililitis?
Opo.
Okay. So you would think this falls under the exception?
Yes, sir. Yes, Your Honor.
So if a justice or a employee of the Supreme Court comes to you and says, "Ma'am, may impormasyon ako." Kasi kayo Secretary of Justice, natural na kayong sumbungan. At sabihin, "Ma'am, confidential man yon, krimen to, o kaya malito, o immoral, or whatever, may misconduct dito," normal na magsumbong sa inyo.
Opo.
And ma'am, alter ego kayo ng Presidente, di ba? All secretaries are alter ego, cabinet secretaries are alter ego of the President.
Opo.
And in your case, you have the alter ego as far as the Department of Justice is concerned.
Opo.
So let me ask you a very sensitive question. Pause for a minute. Dun lang po ba sa dissenting opinion po, nabuo yun yung opinion na may maniubra dito as allegedly, no? Dito sa TRO na to? O meron din po bang nakaabot sa inyo, whether diretso or napasa ng kwento, about what happened and how they deliberated on it?
Can I have 1 minute?
Yes, please.